Hey, listen, everybody. Thank you so much for coming. This is actually the first event that we've done at the center in the new world. And, usually, we have food and we have all this stuff we can share together. There is food coming, and actually, it's really good food. I maybe should say this is being recorded. It's not from here. We decided because this was Black History Month, we went out and got actually Tashana Santos, who's our wonderful member of our team, who's actually on vacation this week, went and ordered the food from like a Jamaican place so that, we have some authenticity. So absolutely stick around. The food's coming. We wanted it to be hot, and we also wanted people to come up in the room before they actually took the food and went home. So, listen, I'm David Wilkins. I'm the faculty director of the Center on the Legal Profession. I see, even despite the mess, some old friends around the room, which I'm very grateful for. That's Brian Fong, who's our executive and research director, and we'll be talking a little bit about some of the research that Brian and I have been doing. That's Megan Dobb, who's our current research fellow. And we will be introducing John Bliss, who is a former research fellow, who's going to talk a little bit about some of his research. And outside, waiting for the food, is Dana Walters, who's our lead writer on our digital magazine, The Practice, as well as kind of the person who's helping to coordinate our Student Fellows program. And so one of the things I want to plug here is that if people are interested in this kind of work, we do try to integrate students in the research that we do in lots of different ways, and Dana's the right person to talk to about that. Okay, so listen, I want to talk a little bit about why not just Black Lives Matter, but Black lawyers matter. And I'm going to talk a little bit about it with respect to some of the research and other activities that we've been doing at the center. As many of you know, we are a kind of empirical research organization trying to understand the cutting edge issues of the legal profession. And one of those big issues has been the changing demographics of the legal profession. And we've been particularly interested in this with respect to lawyer careers, and even more in particular with respect to the careers of Harvard Law School graduates who we've also been studying. So in 2000, God, I can't believe almost now more than 20 years ago, I organized the first ever reunion of Harvard's Black alumni, which, as I'll say in a minute, is the second largest group of Black lawyers ever graduated from a single law school. And as you can see, we assembled quite a number of people. There were, I think, about 700 people who came to that first event out of a population of, say, 13 or 1,400 living Black alumni. So we got a tremendous turnout. And one of the things I said if we were going to have this gathering was we should document it, both with respect to the history of Harvard Law School's Black graduates, as well as with respect to their kind of contemporary careers and challenges. And so we wrote a report called the Report on the State of Black Alumni that contained what at the time was, without question, the most kind of comprehensive, definitive study of the graduates, really, of any law school, but particularly the Black graduates of any law school. And at the time I did this study, it was way more comprehensive than anything we knew about Harvard Law School graduates in general, because no one had ever studied them. Eventually, Brian and I and a number of others did that in about 2015. In any event, the event was so successful that I was convinced that I should do it every 5 years. And so in 2005, we did it again. In 2015, we did it again. And in 2010, we did it again. And we were supposed to do it in 2015, but for various reasons, it got pushed to 2016. And at 2016, I said we ought to reprise the study that we did in 2000 to see what had changed. And so we did. We got over 850 survey responses out of a population now of about 16 or 1,700 black Harvard Law School graduates, and we wrote this report. Both of these are available on our website, and if you're interested in not just the careers or the history of black Harvard Law School graduates or black lawyers in general, because we try to chronicle not just the history of our own graduates, but in general that history, but also if you're just interested in the kinds of issues that I want to talk about today at the intersection of personal and professional identity. They have a lot of rich information about that, including something that I'll mention here briefly, gender differences within the population of black graduates. That is, oftentimes we talk about gender and race as separate things, but of course, as we will talk about in a second, they are not just separate things, but they're also intimately intertwined. So, basically, you can find out about the kind of progression of black graduates, which starts actually, 4 years after the Civil War with George Lewis Ruffin, who became not only the first black graduate of Harvard Law School, he became the first black person to receive formal legal education in the United States. There had been, you didn't have to, as many of you know, have formal legal education in order to become a lawyer. And even before the Civil War, a tiny number of blacks actually managed to become lawyers, notwithstanding all the obstacles that faced them. But Ruffin was the first black person to receive formal legal education in the United States. Over the next 143 years, as I've suggested, Harvard Law School has become the second most important source of black lawyers in the country. Second only to the great Howard University School of Law, which you will see history is intertwined with that of Harvard's. And arguably, no black graduate has had more of an impact, not just on the black legal profession, but on American law and constitutional democracy more generally than Charles Hamilton Houston, whose centennial graduation we are celebrating this year. He graduated in 1922. He was a superstar law student, the first black graduate, the first black editor of the Harvard Law Review. We think, though records weren't kept all that accurately back then, he graduated #1 in his class. And then he did what most black lawyers, almost all black lawyers of his generation did. He went to practice in a kind of solo practice setting where actually he joined his father's law firm, who had graduated from Howard Law School several years before, making him a quite unique character. But he was eventually persuaded to become the vice dean of Howard Law School, which was essentially the dean that ran the law program. And from there, as many of you know, he created the kind of step-by-step litigation campaign that eventually resulted in the landmark decision of Brown versus Board of Education. If you don't know that story, I urge you, we tell it in our reports, but I urge you to read Richard Kluger's Simple Justice, which is perhaps one of the greatest books about law ever written, which chronicles this journey. And the point of this is that, Brown wasn't just iconic for the rights of black Americans. Brown basically rescued the promise of American democracy chiseled on those words on top of the Supreme Court of the United States, equal justice under law, from the hypocrisy of Jim Crow and slavery and all of the other issues that had really denied the legitimacy of the claims made in the Declaration of Independence and the Constitution, etc. Look, but here's the point. Although Brown signaled the end of de jure segregation first in the public schools and then in a series of decisions in other areas of American life, it did not end de facto segregation, and certainly not in the legal profession or in legal education. And just as one Harvard tidbit, the class of 1965 at Harvard Law School had exactly the same number of black lawyers as the class of 1869, meaning what? Turned out that was a very famous person named Conrad Harper, who went on to become the president of the New York Bar Association, the first black partner in a major law firm, lots of other things. But that's incredible, right? In part because of the pressure of that and a number of other events, which if people are interested, I'm happy to talk about, Harvard actually instituted the first kind of real program. You could call it an affirmative action program. You could just call it a program to try to desegregate legal education in the history of the United States by creating a summer program that brought about 20 or 25 very talented black juniors and seniors from historically black colleges and universities to Harvard for a summer program to both interest them and prepare them to apply and go to law school. Now, the interesting thing about this program is that it was expressly created by Dean Erwin Griswold not to be a feeder for people to come to Harvard Law School. I think Griswold was afraid that somehow if he created this program that there would be pressure to admit some of the students, and so he basically put a rule that said you couldn't admit anyone who was in the program. But it turned out that two of the students who went to the program were so talented that literally members of the faculty, some of whom are quite famous today, like Alan Dershowitz and Frank Michelman and Frank Sander, went to the dean of admissions and said, you have to admit these people because they're as good or better than any of the students we currently teach. And they turned out to be right. One was Reginald Lewis, who became the first black billionaire in the country and who gave the money for Lewis Hall, which many of you either have been in or will be in. And the second was a guy named James McPherson, who didn't really practice law very much, but all he did was win the Pulitzer Prize in fiction and become awarded a Genius MacArthur grant. So I think they did pretty well with that so-called affirmative action program. Look, more than half a century later from that program, you can find, and the reports chronicle, black graduates in every echelon of American society and the world. And for my LLM friends, I apologize. We did not study LLM students in that survey, but I hope that we will do so again, because if we add the LLM students, then we really have an incredible global presence of black Harvard Law School graduates. And of course, in 2008, that number came to include somebody with big ears and a funny name named Barack Hussein Obama, and even more importantly, in my view, because she was in my first class of students, his wife Michelle Obama, who became President and First Lady of the United States. Okay, lots of change, but the same. The more things change, unfortunately, the more they stay the same. Look. Here's the good news. There are now 65,000 or so black lawyers in the United States. And you have to understand that in 1960, when that program was underway, there were less than 2,500, there were like 2,200 black lawyers in the entire country. But black lawyers still only constitute 5% of the members of the bar. And when we look at positions of power and influence and prestige in the legal profession, that number is much less. Just as one example, in 2019, there was an article in the American Lawyer, some of you may have seen it, that 7 Am Law 100 firms had no black equity partners. None. And another 20 had only one, okay? And this is now 60 some odd years after Brown versus Board of Education, right? And the progress has been especially slow for black women, who, notwithstanding the fact, constitute more than 50% of all of black law students and black law school graduates since the 1990s, right? And this is true at Harvard Law School, and it's even more dramatically true in many other law schools, still only constitute fewer than 1% of the partners in these law schools, or really it's more like 0.65% or something like that, and less than 2% of the federal judiciary. And of course, most black lawyers don't have a chance to become partners at law firms or federal judges. Most of them work in a manner and make the kinds of wages that Thurgood Marshall did in the 1930s by representing black individuals and small black businesses, which led W.B. Du Bois to call black lawyers a, quote, starvation profession, okay? That's the fate of most black lawyers. And of course, by every economic and social measure, of which John Bliss will talk about some in a little bit, black Americans lag behind whites in almost every category of income, wealth, opportunity, and, for our purposes, significantly access to justice. So, events since 2020 have only accentuated this divide, or at least shown a bright spotlight on this divide, right? The coronavirus, even in its early days, many of you will recall in March and April and May, these stories that said, gee, we're really surprised that, the death rates and the rates of infection seem to be much higher in minority and particularly in black communities. Why is that? To which every black person said, duh, it is because they have less access to health care, less access to education, less access, they work in jobs that require them, that are not allowed to be remote, that require people to come, essential workers, service workers, etc., and less access to information, particularly good information. And then, in the summer of 2020, we got these string of atrocities, the murders of George Floyd, Breonna Taylor, later on Ahmaud Arbery, the burgeoning Black Lives Matter movement, which shined a real spotlight, right, on America's racial past and its continuing effects, including continuing effects in the legal profession, which has, in fact, then prompted a response from the legal profession, which is one of the things I'll talk about it after John has his presentation, that we're interested in studying, right? All the programs, the statements, the Black Lives Matter, the Juneteenth, all of that, plus the clients of the legal profession, which for the moment I want to focus on the corporate clients of the legal profession, have pledged something in the order of $50 billion to racial and social justice initiatives. That's a huge amount of money. And there's a reason why this has happened. And that reason is connected to the first part of this talk, right? If you look behind virtually every one of these initiatives, whether it's a law firm or a company or a government or taking down the Confederate flag or NASCAR, Bubba Wallace, whatever you want to look at, there are black women and men who are now in positions of some power and authority as a result of gaining the opportunities that Brown versus Board of Education created, right? So that this is like a dividend. This is a ripple effect. When people say, what are the effects of affirmative action or diversity and inclusion in higher education? We see these effects, right? By these initiatives, which are not, of course, solely because of black lawyers or even black individuals. There are many people who have contributed to this, but you can go, I promise you, in every company or every law firm, and you can find a black person who has pushed these initiatives, right? And you want to just take one example that has a Harvard Law School connection. Ken Chenault, who's the former CEO of American Express, and Ken Frazier, who's the former CEO and now current chair of Merck, have created something called the 110 Initiative, which is to recruit companies, of which they have now more than 50 or 60 recruited, to pledge 1 million new jobs for black inner city workers in the next 10 years. Both of them, as you can see from their graduation years, are black Harvard Law School graduates. But this growing black political and economic power has also generated a backlash. And, the most visible manifestation of this is the current case, which has now been accepted to be heard by the Supreme Court of the United States next year, notwithstanding the fact that every federal judge that has looked at it said that this is constitutional and did not infringe the right of Asian Americans. this case now puts in jeopardy the very programs that produced the Brown dividend that I talked about. All of this has been crystallized by this event, right? Which is in February of 2020, just a couple of years ago, almost to the day, Joe Biden in the South Carolina primary, where he was, his campaign basically was on life support, at the urging of James Clyburn, promised that he would take his first appointment and he would appoint a black woman to the United States Supreme Court. He said, I'm looking forward to making sure that there's a black woman on the Supreme Court to make sure that, in fact, we get everyone represented. He's now about to make good on that pledge. I think it could have happened today, might still happen today, but it's probably going to happen before the end of Black History Month. Trust me. But this move has generated an incredible amount of controversy, and it's being reflected about ideas about the potential nominee, who people don't even know who that nominee is, her credentials, and lack of objectivity or bias, right? Roger Wicker, who's the Senate Republican from Mississippi, brought both of these tropes together, I'd say beautifully or eloquently or whatever you want to say, in the following statement, right? He said, the irony is that the Supreme Court is at the very time hearing cases about this sort of affirmative racial discrimination while adding someone who is the beneficiary of this sort of quota, right? Implying both that the nominee will not be competent and also that she will be biased in favor of the interests of black plaintiffs. The tactic's not new. And if you've been reading, something just came out in the Boston Globe, Ken Mack just wrote a piece to this effect, that similar attacks were made about Thurgood Marshall's qualifications. Strom Thurmond, ironically the Democrat from South Carolina at that time, subject Marshall to an hour-long grilling, right, about the minutiae of the passage of the 13th, 14th, 15th Amendment, to imply that he didn't understand those amendments, even though, ironically, Marshall had done more than any other living human being to actually make those amendments meaningful. Senator Eastland, Democrat from Mississippi, went even further, saying that Marshall, because of his prior stand, had a, quote, hatred against white people, and that he would not give white Southerners, quote, fair and square treatment. This is not new, basically, or did not stop just then. Basically, every federal judge throughout the 60s and the 70s was subjected to this kind of attack, and it didn't stop when they went on the bench. So our colleague, Tomiko Brown-Nagin, has written this great book about Constance Baker Motley called Civil Rights Queen, in which she recounts that in 1975, defendants in a sex discrimination case moved to disqualify her on the ground that she must be biased because she was the first black woman to be appointed to the federal bench and had spent her life as a civil rights lawyer. Look, Marshall and Motley and others were able to fend off this critique, but it doesn't mean that it went away. In fact, this idea that there's something about the relationship between racial identity and professional role that is in conflict persists, right? And it's not just whites or conservatives who have said this. So some of you may have also seen Judge U.W. Clement, who was the first black federal judge of the state of Alabama, wrote a letter to President Biden urging him not to appoint Ketanji Brown Jackson, one of our graduates from 1996, to the court. Why? Because she had ruled against class certification in a case of black workers against Lockheed Martin. Now, just to be very, very clear, Judge Clemens's credentials as a civil rights lawyer are unimpeachable, okay? He worked at the Legal Defense Fund, after graduating from Columbia Law School and Columbia College, which he only went to because he was denied admission to the University of Alabama. He's one of the first 10 blacks to ever be licensed in the state of Alabama. And he brought a variety of school desegregation cases and even sued Bear Bryant, the legendary Alabama coach, to desegregate the football team at Alabama. So his credentials are unimpeachable, okay? But he now practices law in a plaintiff's law firm that brought the Lockheed case, and some people now are accusing him either of being unprofessional for not disclosing that, or for engaging in the same kind of stereotyping that says a black judge can't be fair, as was brought against Marshall and other judges, right? So this question is there, right? And what we'd like to do in this session is to give you some idea about how to think about this or make sense of this, okay? Because this really raises a deeper set of questions. What should be the relationship between who you are and what you do, right? As my legal profession students know, the traditional answer for this was there really shouldn't be. That once you become a lawyer, you adopt a kind of professional identity that supersedes everything about you, and that you are governed entirely by a kind of professional ethic, right? Of what it means to be a lawyer, which is to abstract away who you are as a person. And there's reasons why lawyers have this, and quite frankly, why it's been appealing to lawyers, even black lawyers. It's because, one, the idea of the rule of law is about neutrality and predictability and objectivity, and it seems to protect those subject to the rule of law or subject to lawyers from idiosyncratic views about who the lawyers were and what they believed. And at the same time, it also protects people who become lawyers from the very charge that's being leveled against Marshall or perhaps Ketanji Brown Jackson or whoever is nominated, that who you are outside of your judicial role or your lawyer's role is going to somehow compromise who you are within. All right? I wrote a whole article about why these are powerful. But the article also says that the problem is we also know that they're false, or at least not fully true. It's false because nobody is abstracted from who they are, right? Lawyers are people too, contrary to all popular belief. And that professional norms are not independent of identity. And just a way to think about that is, the ABA did not allow blacks to become lawyers because they were deemed unprofessional until 1943. Okay, not 1923, 1943. Or in a study of Wall Street lawyers by Erwin Spiegel in the late 1960s, he said, look, here's who Wall Street lawyers think are professional. They're men who are Nordic, have pleasing personalities, clean-cut appearances, graduates of the right law schools and the right social backgrounds and experiences in the affair of the world, and endowed with tremendous stamina. As I tell my students, tremendous stamina is still required, but there are not enough clean-cut Nordic guys to go around. So the fact of the matter is, though, this was the notion of professionalism. So they have to ask ourselves, what is the relationship? And it's not just a problem for black lawyers, right? As Leon Higginbotham, another judge confronted with a similar thing that Judge Motley said, look, black lawyers have litigated in the federal courts almost exclusively before white judges. Yet they've not urged that white judges be disqualified on matters of race relations. In other words, white judges have identity too, okay? And if we look beyond race and gender, we all have a huge number of other factors of our identity: religion, politics, family, and those unique things that make us who we are, right? And finally, Brown casts itself a shadow that every lawyer has to deal with. And that shadow is a complicated one, because I'll call it a dual legacy, right? On the one hand, Brown promises equality through integration, which implies that if we just provide equal access and opportunity, that's all we're obligated to do in order to produce a just society or a just result. But Brown also promises social justice through law, which says that it's not just about producing equal access and opportunity, that law is supposed to be a positive instrument for social change. Navigating the tension between these two things is particularly an issue for black lawyers or black law students who are themselves literally the inheritors of both of these things, right? They have their opportunities because people opened up opportunity and access, but they also are the products of a vision of social justice through law. And they are also acutely aware that the pursuit of the first doesn't guarantee the second. In other words, just because you change the demographics of the people who are in power doesn't mean that the power changes. But they are also acutely aware that trying to pursue the second exerts a much greater challenge and risk to them than it does to others because their credibility and competence is already questioned. But all of us face this challenge. All who become lawyers face the challenge of what is it that is required of us by the relationship between lawyering and justice. In a world in which we both know that the world is riven with injustice, and we also know that the rule of law is more important today than it ever has been. Okay, this is hard. So we're going to try to give you an opportunity to think about this. And I'm going to turn to John Bliss, who has done some very interesting work, both around how a particular lawyer who's often undervalued in history dealt with these issues, but more generally how to think about them. And then, I'm going to come back and talk a little bit about a project that we're doing now. So, John, please.
So, as Professor Wilkins mentioned, I study these issues of how lawyers think about their personal values and identities and how that fits into being a lawyer. In fact, most of my work involves law students, interviews with law students, including the project that Professor Wilkins will talk about at the end. But today I want to offer a historical example. This is from some archival research I've been doing because I think Lauren Miller, who's one of the early attorneys of the sort of pre-civil rights movement, is a pretty extreme example of these identity tensions where he grows up in, I'll talk a little bit about his background in terms of poverty and discrimination his family faced. But the main contrast is between his 20s and his 30s. So in his 20s, he's graduated from law school and he's working full-time as a journalist, basically full-time attacking the NAACP and lawyers in his columns for not being militant enough, not being focused enough on kind of large-scale de facto change. And then in his 30s, he becomes one of these lawyers and actually ends up sort of reconciling some of his values with what he can do in the legal profession, in particular the issue of racial covenants, where he ends up being the lead attorney nationally. So he grows up in the Midwest. His dad is black and his mom is white, so he faces discrimination sort of on multiple grounds, and the family struggles with housing and employment. His dad at one point has a job as a janitor in a courthouse, and that's where he observes law in action and gets interested in going to law school. But this experience of race and class ends up being really central to what we see in his 20s, where he turns to writing and journalism. And he's very unpersuaded by this professional class of lawyers as a conduit to the kind of actions he's interested in. So to jump to the second bullet point, He says just getting civil rights isn't going to get food, clothing, and shelter, and he thinks lawyers are sort of serving their own interests and not the citizens. He's, by the way, he's writing for communist and leftist outlets and also black press in Los Angeles. And he views the NAACP as engaging in this kind of gooey prattle, he calls it, and focusing on not enough on the working class. He goes to the Soviet Union to make a film about US race relations with Langston Hughes. And it is, at this point, if you said this was going to be someone who defends property rights of black homeowners, it would be pretty surprising because he doesn't believe in property, right? He's a very committed Marxist. Nevertheless, it turns out you don't make a great living as a Marxist journalist. He has a law degree, so in his 30s he says, okay, we need to make a better living, so he gets into practicing law. And he actually starts to see some threads between his ideology and his background and this issue of racial covenants. Because racial covenants laid the foundation for the American ghetto system, which, and this apartheid he views as the most important inequality issue of the day. And he brings his skepticism of law into his practice by opposing legal formalism, by arguing that the judiciary cannot shut its eyes to real-world effects. And I'll give you a couple really innovative and dramatic examples in a moment regarding racial covenant litigation. First off, maybe not everyone's familiar with racial covenants. If you had first-year property, you probably are. This would be something that you could see in home deeds, especially the 1910s to 1940s, that would be created by developers or homeowners themselves, and would say that this property can only be occupied by people of the white Caucasian race. Here's an example of a list of covenant restrictions. I'll just throw in the titles over the top. Most of the stuff you'll see today, residential purposes only, no businesses, certain size of lots, no subdividing, etc., no non-white applicants. And this was a boilerplate. This was pervasive in the first half of the 20th century. It looks like they were very effective. This is a study in Washington, D.C. The purple are lots with racial covenants. This area is lots with 80 to 100% non-white population. And it looks like the covenants form the boundaries. Causal arguments are difficult, but it looks like they had a pretty dramatic effect in not only creating a separation line, but also limiting the opportunities for housing. So what you end up seeing, and this is across US metropolitan areas, is black communities moving into new cities outside the South in the early 20th century and not having many housing options, and living in overcrowded neighborhoods, actually paying above market because of the restricted supply of housing. So how does Miller approach these cases? Generally, he's bringing the constitutional arguments that end up winning, but he actually takes it further in this high-profile case in Los Angeles, the Sugar Hill cases, which involved a lot of black celebrities, including Hattie McDaniel, who had just been the first black recipient of the Academy Award. And he shows up for this trial with an objection to all evidence, 2 law review articles saying that racial covenants are unconstitutional, and an invitation to the judge to visit the neighborhood. And he actually finds a sympathetic judge. This is the only case before Shelley v. Kramer, the big Supreme Court case that renders racial covenants unenforceable. This is the only case that wins on constitutional grounds. So he finds a sympathetic judge, and his opening statement's all about the context of racial covenants. He brings the judge out into the context and says, see, the world hasn't fallen apart. There's some racial integration in the neighborhood. These covenants are just racial animus and nothing more. And he actually wins. And actually, there was a good chance at the time, it seemed, that this would be our Shelley v. Kramer. This was the case Thurgood Marshall liked. It turned out that an attorney in St. Louis sort of went rogue went against the NAACP plan and brought his own case to the Supreme Court, and the Supreme Court was open to hearing it. And then the NAACP jumped on board with him. I'm not going to take time to talk too much about the national campaign, but just to say that on the top are some of the local attorneys that were bringing racial covenant cases in different jurisdictions. Indeed, the cases that ended up going up to the Supreme Court with Shelley, and were activists in their communities, religious and political leaders. Loren Miller, with his leftist orientation and his focus on social change through journalism and politics, not only law. Charles Hamilton Houston, who, having trained with some of the realists here at HLS, Pound and Frankfurter, was very convinced of the importance of sociological research, and so they actually brought to the Supreme Court more sociological research than they'd ever seen in a civil rights case, more amicus briefs, showing that these covenants had a real-world impact. You can't look at them as purely private devices, the way that courts had tried to describe them in the past. And then, of course, Thurgood Marshall, who didn't argue the case, but was in this sort of organizing role in the leadership. So I guess the last thing I'll say is the impact of the case, and then a little update on Miller. So Miller's point all along is you can't solve things only with law. It has to be part of a larger campaign. Indeed, you still have segregation continuing after Shelley, in part because housing discrimination was completely legal in every jurisdiction. And fair housing laws only started being passed in the late 50s and nationally in the late 60s. And then there's other mechanisms. So this is a life expectancy chart. This is where I started conducting this research in Oakland, California, and Alameda County more generally. And life expectancy tracks neighborhoods, and in fact, neighborhoods are one of the strongest predictors of your health and life expectancy, overlapping with race, because neighborhoods largely overlap with race. But you're talking about, in some of these neighborhoods, a 15-year difference in life expectancy. So you're talking about very, very different worlds. And intergenerational wealth, obviously tied to owning homes and people being denied the opportunity to own homes and build wealth over generations, as we see in this chart. I'll just say to wrap up, that this ties into my larger research agenda, my sociological research about how law students, this is an example of a law student, and lawyers think about their lawyer role, their big law firm job perhaps, relative to their personal identities, and the exercise here is to put these roles closer to the center if they're more important to making up who you are. And there are a lot of these experiences in my work of people feeling alienated from the lawyer role. Maybe in this case feeling like, I'd like to be doing more impact litigation and civil rights, but it's not what I'm doing for my first job. And it's harder to kind of translate those values into the kind of work that I'm doing. And I think Miller stands for an illustration of this kind of discomfort with professional identity that he actually turned into a really uniquely anti-formalist approach to litigation, and ultimately a hugely impactful legal career. His transformation into full legal identity, not full legal, I don't think it would be his whole circle, but the transformation was pretty robust when he argued in the Supreme Court for Shelley v. Kramer. He argued the next racial covenant case for damages. He wrote the majority of the briefs in Brown v. Board, and then he became a judge. So it's an interesting arc. Hopefully it's a helpful illustration for thinking about how these tensions can play out. And it's certainly something that we're thinking about with, to hand it back over to Professor Wilkins, that we're thinking about with the projects that we've been developing with Black law students. including this identity exercise and focus groups and interviews.
Thank you. It's just a fascinating story, and I urge you to read John's work both on that and also on identity. I'm just going to say very briefly, because I want to leave time for questions. This is a really unique moment, right? I tried to sketch some of it out in my earlier presentation, particularly to be a black law student. I mean, imagine, you show up in the fall of 2020, you don't even know. Well, first of all, you get accepted to law school in 2020 before the world falls off the cliff. You think you're going to law school. Then all of a sudden you go remote the whole year, but before you show up, the Black Lives Matter movement galvanizes the country. Coronavirus is rampant. And you show up in the middle of a presidential election in which the sitting president refuses to concede, right? And in which issues of race and identity are everywhere, leading up until January 6th. And then you think about all the things that have transpired afterwards. Our interest is, what has this meant for how one group of people, but again, I want to stress, I think this exercise is relevant to everyone in this room and everyone at Harvard Law School and everyone who's gone to law school at this time. How has it translated for black law students thinking about what it means to be a lawyer in the kind of way that John has sketched out? And so we've been doing some focus groups, we've been talking to some people individually. We're very interested in continuing these conversations as people move forward. In other words, have they felt about what most law firms did, for example, if they're going to a law firm? Has it changed their interest in going to a law firm? What about the clients? What about the diversity scholarships? What about the mobilization and legal mobilization issues? So there's a huge number of things that are going on, and the question is, how does it affect this set of questions about the relationship between personal and professional identity? And I'll just close by saying these aren't ever going to go away. And I think they're only going to become more important as the legal profession becomes more diverse. And, many of you were born outside the United States, including many of the black students in our current sample. What does that mean about the way in which they think about race, or the number of people who claim more than one racial identity, right? Like Lauren Miller, the number of multiracial students, the number of students who come with work experience and therefore with a lot of pre-existing ideas about what they think law and justice ought to be that they formed before they went to law school, right? How are all of these things going to affect what we do here? Which is, how do we think about what it means to be a lawyer in this kind of environment? All right, let me just stop there. Any questions or comments? It's not class. I'm not going to call on anybody. You can ask John more about the fascinating story about Lauren Miller, but we just wanted to give you at least an opportunity. I'm used to long, uncomfortable assignment. I see my former students feel sorry for me and they raise their hands. Go ahead, Ashwari.
Professor, we spoke about the affirmative action case that the Supreme Court will be hearing next year, and with the Chief Justice not being a fan of affirmative action as he has spoken about before, and with the court becoming increasingly conservative. What, in your opinion, what do you think? Do you think this will mean an end to affirmative action programs?
So I'm both pessimistic and optimistic. It won't surprise you, Ashwari. I'm pessimistic as to the actual result. I've actually known John Roberts since he was a law student. I'll just leave it at that. If you look at what both he said and what other people have said, and if you look at the politics of this, because remember, it's also coming through at the same time the abortion decisions are coming through. You don't have to be too much of a legal realist to think that there might be some trade-offs that might be made between the various kinds of big ticket items that are coming through the court. It's probably heresy in here, but it's nevertheless, I think, likely to be true. So I think it's very unlikely that affirmative action will survive in its current form. That's the pessimistic part. The optimistic part is, I think the train has left the station on this issue. Meaning that if you look at what's happening in the world, and particularly you look at what's happening with the demographics of all sorts of issues, I think it'd be very hard to shut down the movement towards greater diversity and inclusion that's already going on. It doesn't mean it won't slow it down. It doesn't mean that there won't be places where it's harder than others. But I think this movement in corporate America that we've seen so far, I mean, one can argue, and I bet a lot of you have arguments about how genuine it is, how much are they really going to change. But the idea that you would ever go back to that quote I read you about what we're looking for in lawyers is clean-cut Nordic guys, with the right social backgrounds, not only is it unlikely, but it's actually impossible given the diversity in the world today. So I think, like a lot of things, the Supreme Court decision, just like Lauren Miller would say, the Supreme Court decision it's not that it's not important, but it's neither sufficient to produce actual social change, nor is the opposite of it sufficient to stop all social change. And so I think the battlegrounds will shift, that there are a lot of people who are in positions of power and authority who are going to continue to push, and that includes not just Black lawyers, but lawyers who have grown up in a world of diversity that they are proud of at least trying to create. That's my optimistic part. Other thoughts, comments, questions? You don't have to have any. I guess what I really hope, and I really do hope you go out and eat the food, because there's a lot of good food out there, and we bought it, and we want you to eat it. But if you have thoughts about this, it could be about what it means for this Supreme Court nominee, it could be for what it means around affirmative action, what it means about diversity at Harvard Law School, but it could also be in a totally different context. So another thing you and I have talked about is how these issues are playing out in India. I have students from Brazil where these issues are playing out, students from China where these issues are playing out. This question of what's the relationship between who we are and what we do, I think is one of the most fundamental there is. And it's one that everyone should spend some time thinking about for the reasons that John kind of hinted at with Lauren Miller. That if you live in a world in which there's a huge dissonance between these things, it's a very, very, very uncomfortable place to be, And it's not likely to be a productive place either. It's neither happy nor productive, right? There's no such thing as a perfect confluence, right? And this is partly why I think this issue, the critique of Judge Brown Jackson and ruling against Black plaintiffs, well, to become a federal judge requires you to have allegiance to certain kinds of norms. To be a professional, it requires you to be a lawyer, to have allegiance to certain kinds of norms, which might mean that you can't always do the thing that if you weren't a judge or weren't a lawyer, you would be in favor of doing or think even is the right thing to do. In the paper, which if people are interested in either reading it or sleeping better at night, it's, about 80 pages. It's called Identities and Roles, Race Recognition, and Professional Responsibility. Basically I argue that you've got these three kind of spheres that you all have to be paying attention to at all times, right? There's the sphere of your professional sphere, about what it means to be a lawyer. There's the sphere of group identifications which are important and meaningful and have a real call on you, of which the one I write about is race, and particularly in the context of black lawyers. But then there's the sphere of who you are that is unique from all those things, or maybe the composite of all those things that you also owe something to. And the question is how to think about those things in a way that doesn't either essentialize any one piece of it. That's what's wrong with the critique of Marshall, that's what's wrong with the critique of Kitaji, but it's also what's wrong with the critique, the kind of individualistic, I get to do whatever I want and it doesn't matter if I have any connection with it, when it differs is because I'm unique and I'm me, I gotta be me, as Frank would say. Sorry, no, you're too old and young to know that song. So how do you navigate these things, right? I call them semi-autonomous social fields, borrowing something from anthropology, actually, and sociology. But I urge you all to spend some time thinking about it for yourselves. And one thing that John's research allows you to do is gives you a visual for how you put these things together. And what John does also is he sees how that changes maybe over time. If Lauren Miller had filled one out when he was in his 20s, it probably would have looked a lot different than the one he filled out in his 40s. And that's the last thing I'll say is don't forget that you guys have careers. You don't just have jobs. You don't just have moments of decision, although those things are important, like, where are you going to go next year, or what are you going to do this or that. But you also have a life and you have a career. And that is something that you can try to build integrity into, that takes advantage of what, I forget who said that, we talked about the moral remainder. It's when you have to take an action that will slight one thing or another, that both of which are important, Michael Walzer, that you should honor that thing that's left over, even if you can't honor it at the moment in action. And maybe it is that you pay attention to make sure that you're not constantly sliding something that's important over time. And that requires you to think of your life as a life, as a trajectory, and not just as a series of isolated decisions. All right, I've talked too long. You got to get the food. You got to go out. If you want to learn more, please contact me. I can put you in contact with John. There's Dana, who guarded our food. I already introduced you. And I hope you'll read our digital magazine, The Practice. Go look at the research we do, and I hope to see you all around. Thank you. Thank you.